Yes, good evening to everybody. Welcome to the class. And yesterday I told you that I'm going to deal that today nervous shock. In other words, we can say psychiatric illness. Yes, please read what I posted on the screen. Anyone?
Nervous shock. Thus, a man who came up on a scene of serious accident for acting as a rescuer when suffered a nervous shock was allowed to claim the damages. In Wilkinson versus Downton, 1897, the defendant, by way of practical joke, informed the plaintiff that her husband had broken his leg in an accident. The plaintiff got a nervous shock and became seriously ill. The court held that the defendants were liable.
Yes, because I told you this case law, Wilkinson versus Downton, making a practical joke, stating that her husband was met with an accident and her legs are amputated in the accident. And now he's taking rest over there. By hearing such a joke, she got a nervous shock and she became out of senses also. Let us say, he may be have gone in the coma also, and seriously ill. And then the court held that the defendants were liable because it is nothing but a nervous shock. Sorry, nervous shock is an insult, sir. Nervous shock is unhappiness. Nervous shock is a sorrow. What is the nervous shock and where do you make it out? So if you happen to see the Nichols and Chin says that the nervous shock, I quote, a label refers to a wide range of the recognized psychiatric illness. It is a psychiatric illness concerning the neurology, brain, and such as a phobic anxiety, phobic anxiety, a fear. Phobia means fear. So neurosis and a post-traumatic stress disorder. In other words, we can say PTSD. There is a post-traumatic stress disorder, which are more than simply a grief. It's not simply a grief, or upset, or unhappiness, or insult. So it is more than that is there. Suppose if you have gone to the doctor to test whether you are a HIV positive or not, and the doctor told you, yes, you are a HIV positive. By hearing that doctors say you got a nervous shock, can you file a case against the doctor?
No, sir, we can't file.
Why?
Because it is our own will to know whether we are HIV positive or not.
See, you are gone over there to know whether you are HIV positive or negative. Suppose if you have the chicken heart, you send a friend to get it by showing the prescription what he wrote or receipt. And your friend slowly will say, no, nothing is there, this thing, that thing. He takes the time. When he takes the time, and there would be a lot of, then he takes the time, there is a lot of time would be there to recover him. And that is the reason we can say that. Otherwise, if you say that totally at the time, then it will amount to a nervous shock. So slowly time would be there, even if anybody died also. They don't say your father is dead. What they say, no, he's in a hospital and he's asking you and he wants to see you and meanwhile. So when he reaches to the hospital, up to that extent, he's mentally prepared to bear the deathness. So that was the thing which is made. So a person went to the doctor to know whether it's a positive or negative. That means he wants to get the result of it. It is not about a nervous shock. And suppose if you failed in your examination and you got the shock, can you file a case against the teacher because he felt the nervous shock because of stress?
No, sir.
Again, the answer is there. In such things, you cannot make it out. Merely the insult, or the grief, or upset, or unhappiness, or frustration, you cannot make it out because you have to face those things. Because past and failure are common in the things. So John Erickson described nervous shock injuries as a part of the clinical pattern following the railway accident. When the railway accidents are there, a chicken heart man should not supposed to go over there and see. Erickson said that many of the railway accidents lead to severe and prolonged nervous shock because people, those who are traveling in the bogies are crushed. They become a pulp. You know pulp? P-U-L-P, pulp.
Yes, sir. The crush of wood
మన
to make paper.
ఆరెంజెస్లో పల్ప్ చూస్తారు కదా, పల్ప్. ఇంతకుముందు ఆరెంజెస్ పల్ప్ ఆరెంజెస్ వచ్చేసి ఏది జ్యూసెస్. సో యూ విల్ బికమ్ ఏ దట్ మచ్ ఏ చట్నీ. సో people know where is the head, where is the now. It is only a flesh blood, and the pool of blood would be there, especially when a crash, railway crash is there, that will be the head-on collision. So when it's such a thing, if any person goes to rescue there, because they are rescuing, when a person going to rescue there, naturally they feel it, that shock would be there. And where the beautiful case law, we do have it, Chadwick case law. That is the case law which says about the Chadwick. I have given the case law number of the cases. Chadwack, Chadwick case law. So Lord Keith and Oliver Alcock, Lord Keith and Oliver say in Alcock and others, as the Chief Constable of South Yorkshire Police feel that the term nervous shock is a misleading one. So this is the Halsbury, that is the ground case law, where the football ground case law is there. So it's a misleading one. In fact, it covers a wide variety of the possible crimes in that area of negligence. So what I want to say is, nervous shock is not merely a grief. Nervous shock is not merely an insult. Nervous shock is not merely the distress. Nervous shock is not merely the discomfort or unhappiness. It is more than that, which is connected to the neurosis, where a clinical failure would be there and a psychiatric illness would be there. At the time, we can say it's a nervous shock. So we do have the number of the cases here that I already given, and these are the cases which will give the idea what is nervous shock or not. And in this, we have already 2 cases we already dealt. What are the 2 cases we already dealt earlier?
Wilkinson versus Dunton.
What is another case law? Another case law.
Borhill versus Young, sir.
Yes, Borhill versus Young. The other name is Hay versus Young also. Because some books they say Hay versus Young or Borhill versus Young. What is the facts of the case law?
The fisherman wife saw the bloodstains near the tram car track, and due to the death of a motorcyclist, and she gave birth to a stillborn baby.
And she felt the nervous shock, and she gave the premature baby, stillborn baby, the delivery. And she filed a case. She heard only the scream of the accident. When she got down from the tram and went to the place, she did not see anything except some blood stains are there on the road, because the deceased body is taken out. But merely seeing the blood stains or a pool of blood over there, and she got the shock, and that is said to be a nervous shock. But nobody is invited her to there. So when you did not have that much courage to see, then why did you go over there? It's a human tendency. If any music is there, if any sound is there, even that they throw out their children, those who are sucking the breast milk, they will throw it on the bed. They will particularly go and see from the balcony what is going on there, why the people are crying. It's a human tendency, and especially women tendency. So these are the things would be there. Now let us see one after another this case law, the detection. The law relating to the nervous shock has a long history of recognition. The question of recovery for the nervous shock, or we can say psychiatric injury or psychiatric illness, negligently caused by the another, has been one which has perplexed various courts in various common law jurisdiction throughout the world, since it was the first established in the case of the first case law where it is established nervous shock is Byron versus Southern and Western Railway Company. What is the name? In no area of the tort, it is the task of the providing liability more difficult or more contentious than in the case of the nervous shock, where the victim claims is based on psychiatric damage, where the damage is the result of the effect that are suffered of another due to the carelessness of the tortfeasor. But one thing you should have to keep in the mind: a person who got injury in the accident, he is a primary victim. When a person who saw such an accident where he did not got injured, but he saw such an accident, and that is called secondary person. Means primary injury, and we can say primary victim and secondary victim. These are the two words are there. In nervous shock, it is a secondary victim will be there. Actually, he did not get the injury, but he heard and he saw, and that made him to collapse his nervous system. So the secondary victim is the nervous shock. But only one case law where Page versus Smith case law where a person is a primary victim and he got the accident and he was injured a little bit when he was traveling the cart. But still he claimed it because he is having some post-traumatic disorder earlier. With that, it made him to go for the nervous shock. Only one case law, Page versus Smith case law, but the rest of the other case law, all are the secondary victims. So, what exactly the Byron-Shetland case law say, I have given you in your list of the cases. I don't know whether you studied or not. The list of the cases which I have given, there is the nervous shock cases. That I have given a bit little facts of the case law also in that one. Nervous shock cases. The Byron case law, which comes in the last. Suppose if you type it here, it will go there. B-Y-R-A-N. B-Y-R-N-E. Is it? What is the Byron? What is the spelling of the Byron?
B-Y-R-N-E.
B
I
R
B-Y-R-N-E.
B-I.
Not sir, B-Y-R-N-E.
It's a B-Y-R. Yes, yeah. B-I-Y-B-Y-R-N-E. Is it? You are not giving the answer to my question because I saw here case law. Then I have to go again check it Byron case law. B-Y-R-N-E. It is not here. Just now I checked the case law. It is there. Anyway, that Byron case law, what is the name of the case law? No, let me check it. Because we can know a bit the facts of the case law, then we'll have a better idea. Actually, they did not see. There is an accident happened over there. There is an accident happened, and the other person was got the victim of it. That is the case law here. Is it not there in the Byron case law? Just now I studied that case law. It shows the same thing. See, here the case law, it is given here, Byron case law. The first case law, which is makes the things. Yeah. Did you see here? Read anyone?
In the case of Byron versus South and Western Railway Company, can you recover for nervous shock? In what circumstances could people recover for nervous shock? Sir, the facts of the case law are not mentioned there, sir.
So here, various common law jurisdiction they attempted to see. Actually, he did not involved in an accident, but he saw such an accident and where he felt a nervous shock. And with that, they got the compensation from that one. The same case in the Lynch versus Knight case law. It is happened in the same way. There exists some uncertainty as to whether the court can accurately determine the extent of the psychiatric injury. How could you say this is a psychiatric injury and this is not a psychiatric injury? It depends upon the merit of the case. With regard to the appropriate level of the recovery of the that could or should be awarded. How much the time would be there to recover the patient? By deciding it, we can say it's a nervous shock. And this is illustrated in the 19th century case law of the Lynch versus Knight case law. That means mental pain or anxiety, the law cannot value it and does not pretend to redress when the unlawful act complained of caused the alone. Only the mental pain and agony or anxiety will not count it because it will not count as a nervous shock. So, more than that anxiety, more than the unhappiness and causing the phobia, at that instance only we can count it is a nerve shock. Otherwise, we don't consider it is a nervous shock. So, that is actually the point where we can make it out. So, is the nervous shock worth protecting through the tort system? Yes, Because earlier we used to get it only the physical injury. Like we said, we definitely need to address the question when we are dealing with the topic which took a bit long to get recognized. So, do we compensate plaintiff who suffer this type of loss? And if so, why? Because he is not a primary victim, he is a secondary victim. But actually, he did not got the injury in the accident, but he saw the accident and he got the injury of the mental. So the answer seems almost self-evident, that is yes, tort law protects the interest of the individual and adjudicates the private wrongs. It is a judicial proceedings developed through the case law in which the rules of the evidence apply. So faults or negligence is an important issue of the tort law, and tort law is a fault-oriented. Yes, tort law deals with the civil wrongs for which the law provides compensation. It protects the equity principle individuals by providing the compensation for damages so that the status quo that existed prior to the harm can be re-established between the parties. So rationale is there not only for the bodily injury, but any person who got the mental injury also, he will going to get it. It is important to note that cause of nervous shock itself is not enough to make it an actionable tort. Some injury or illness must take place as a result of the emotional disturbances, fear or sorrow. In order for the claimant to receive the damages from nervous shock due to the negligence of the defendant, they must prove all the elements of the tort of negligence. What are the elements of the tort of negligence? Number one, read.
A duty of care exists. There is a breach in the duty. Sorry, sir. A
Read.
duty of care exists. There is a breach in the duty. The causal link between the breach and shock. Shock was not too remote a consequence.
There would be a duty of care exists. Duty of care on whom? Defendant. There is a breach of that duty. Who breached it? Defendant do.
Defendant.
Towards the plaintiff. The causal link between the breach and the shock. What is the link between the breach and shock? Whether it is a aftermath, immediately or not. And shock, not too remote consequences. There is a too remote consequences, the shock should not be there. It is immediately to be happen. Or sometimes it may happen the next day also, depending upon the case law. So there should be a certain thing which is more than the emotions, number one. And here again will they also say whether the love and affection is there or not between the person who got injury and who got the shock. మీరు ఈవిల్ డెత్ చూసారండి, అది చూసి మీరు షాక్ తిన్నారు, ట్రామాలో వెళ్ళిపోయారు మీరు, 3 రోజులు కోమా. Can you bring an action against the producer?
No, sir.
No, sir.
They already told a person with a heart, lion heart, could only see the movie. Children are weak mind should not, or feeble people are not allowed to see the movie. You yourself voluntarily you gone over there to see the movie. Means what is the general defense?
Plaintiff the wrongdoer.
Voluntary not fit injuria. That is the general defense. So historical evolution of the law of nervous shock, let us see that how it is evolved over there. The law of tort is not only codified in the absence of any statutory law, we have landmark cases to be followed as precedents, because the law of tort is not codified law, except some of the provisions are codified. But the mostly our law of tort is based on
Case laws.
Case laws, precedents, decided cases, judge-made law. So these are the things. And with the reference to the law relating the nervous shock, all we have in hand is to study the law by tracing the cases. What are the cases? Whether really there is a lot of pressure would be there on their mind, and because of that he collapsed and he went to the coma and he was not recovered, and he did not become a conscious, and he became a conscious only after 1 or 2 days later. So the law of nervous shock has been evolved over the decades by the courts, wherein they moved from the entertaining the claims only limited to sudden shock to taking a wider and more flexible approach in dealing with the claims of an individual, taking into account the several eventualities. So they will check it whether he can be eligible to be awarded damages or not. Like an example I told you, Suppose if you went to the doctor said that you are HIV positive and it became a nervous shock, you are not going to get anything. So initially the courts were reluctant as well, the slow recognizing the claim of the psychiatric illness, for it was felt that it was attract the dubious and false claims under the grab of the psychiatric illness, and it would be proved very difficult to outline define the precise parameter of the liability under this field. So now, how could you measure it? So much shock is there. That is only the point. So it depends upon the cases. We can say that yes, it is a nervous shock, or it is not a nervous shock. For instance, difficulty for providing the link between the defendant's conduct and a shock to the plaintiff resulting from the conduct of the defendant. What is the breach of a link and what is the shock? What is the link? That the link here is love and affection is the link. Because the love and affection, suppose the son met with an accident and the dad has seen that accident, in front only it is happening, and where the son wriggling for the life in the pool of the blood, and when he saw it and he was taken to the hospital, meanwhile only the son died because of the profuse bleeding, and the father saw it with his own naked eye and he felt a shock over it. And he's become unconscious for the 2 days. At the time, yes, father saw directly the wriggling and the pain of the child. In his front only, the child is died, and he went to the coma, and much disturbance happened to his brain cells, and hence, that can be recovered. That can be because the primary victim is the son, where he met with an accident, and the secondary victim is the father who just saw the son wriggling for the life when the profuse bleeding is going on over there. The law of nervous shock has developed through the case laws only, which date from far back in 1869, that the Byron case law is the first case law, and later on Lynch case law is the second case law. There are numerous English case laws which provide the best picture of the development of the law in this part. One is Lynch versus Knight case law, one of the earliest cases, the component on liability for the mental damage. The comments, however, was in nature of a obiter dicta. Means here obiter dicta means only in the particular case only it will be done. It is not like as a precedent because there is no ratio decidendi. Of course, your contracts are also says this one, and your constitutional laws are also takes this one. It is not taken as a example as a precedent. That's called obiter dicta. Only that case only it will be applicable. So that is called obiter dicta. And the case actually involved an action of defamation. In the defamation case, actually it is. The comment made as follows. What comment? Mental pain or anxiety, the law cannot value and does not pretend to redress. If merely a mental pain is there, or anxiety is there, or distress is there, or unhappiness is there, insult is there, no, it will not come under the ambit of the psychiatric illness or psychiatric injury. When the unlawful act complained of the causes alone through where the material damage occurs, and is connected with it, it is impossible to the jury in estimating it and should altogether overlook the feeling of the party interested. So merely sorrow will not be counted. More than the sorrow would come on to picture, then only it can be measured as a psychiatric illness. In this, the courts made it very clear that the damage that the law takes notice has to be material, something tangible like a bodily injury. If the bodily injury is caused, okay, is the primary victim in the accident. The case which forms the actual starting the point of all the case laws are nervous shock is the case of here. Victorian case law is there. The Victorian case law is make the things. Victorian Railway Commissioners versus Coltas is one of the case law where the Privy Council observed. What the Privy Council observed in the case law, the Victorian case law, it is the same thing. The damages arising from the mere sudden terror unaccompanied by the actual physical injury, but occasioning the nervous or mental shock, cannot under such a circumstances, the lordship think. What? A person who got injured is primary victim. A person who saw such an injury with his naked eye, and there should be a relationship between the person who died and the person who got the shock, then only it will be counted as a nervous shock. So be considered as the consequences which in the ordinary course of the things would flow from the negligence of the gatekeeper. So a gatekeeper, actually in this case law, what happened? No, I read this case law. Victorian Railway Commissioner versus Coltas case law. that the horse-drawn cart is allowed to pass on because the gateman say, you can pass on, no problem. So when just it is passed over there, then the train passed. Merely by seeing the cartman got a shock. So that man is filed a case against the railway company. So whether he can be going to get the nervous shock or not, because it is not touched to him, but he got the shock. But we read this, it is clearly mentioned here in the nervous shock cases. What is the name of the Victoria case law? It is not actually he got injury, but he will allow that. See, the Victoria case law is here. I made it read. Victorian Railway case law, Qualtas. Yeah, it is given here. See, Kennedy held that the driver did owe her a duty of care, a view that departs from the Victorian Railway Commissioner Qualtas. Kennedy J said it would be unreasonable to say that the driver owed her no duty of care. No, because when it is very approaching near to it, he is not supposed to allow the car to pass on over there. But he allowed the car to pass on over there, and here you read the case law, facts of the case law. Read.
Facts. A couple were driving home in a horse and buggy and came across a rail crossing. The guard said they could cross. A train was approaching and they only just made it across. The claimant, Mr. Coltas, faints and suffers a psychiatric illness as a result. Held. The Privy Council held that no duty of care was owed in respect of her psychiatric illness. Sir Richard Crouch showed he was cautious of extending liability to these types of psychiatric illness cases, and so found such a claim by Mrs. Coltas was not acceptable. He said if we found cases where the initial injury was nervous or mental shock to leave the defendant liable, this would be extending the liability for negligence much beyond what this liability has hitherto been held to be.
So here whether his Coltas is going to get the compensation?
No, sir.
See, the train passed. Okay, just when the cart, the cart buggy, they say no, horse and a buggy, that means horse-drawn cart, you say buggy, it passed over there. But the claimant here, Mr. Coltas, faints because it just passed. Otherwise, and suffer a psychiatric illness as a result. So the Privy Council held that no duty of care was owed in respect of her psychiatric illness. Sir Richard, because it is not touched at all. It is just passed. So when the Richard Crouch showed that he was cautious extending the liability to this type of psychiatric illness cases, so found such a claim, maybe the Coltas was not acceptable. It is not a psychiatric illness. Okay, somebody is got injured and he saw it or she saw it and got fainted. Because somebody got injured, because the buggy is dragged to a certain extent, the fellow is dragged to at least 1 kilometer and he died over there and he saw the screams over there. Okay, now we can say, yes, she was present on the spot and she heard and she got fainted. Yes, at the nervous shock. Yes. Otherwise, for everything we cannot say nervous shock. That's my point. So here they say, in the another case law is there. Here only the thing would flow from the negligence of the gatekeepers. The gatekeepers allowed them. Okay, it doesn't mean that he has allowed them, they passed also. And there is no accident happened. And the buggy already went. But just merely passing that she got fainted over there and she is not entitled to get any compensation. Because if they are going to give such a compensation where there is no negligence of duty is there, naturally the cases gates will be opened for the nervous shock. So in 1901, however, the courts adopted more liberal approach in deciding. In one of the cases, they approached the liberal approach here. Dooley versus White and Sons. In this case, what happened? The mother actually did not see the boy. The mother is on the first floor. The boy is playing in the down on the road. When lorry is taking back, lorry is taking back, the boy screamed it. Actually, the lorry is not run over by the boy. Lorry came at the back. The boy screamed it by the screaming of the boy, and the mother heard from the balcony, and she fainted over there because my son has come under the lorry. Actually, he come under the lorry, but he was not crushed. He was between the two tires. Are you following me?
Yes, sir.
So in this case, it was noticed that shock must be such arise from the reasonable fear of the immediate personal injury to oneself. This case brought into the picture that is called impact theory. The impact is left over there, mother, my son is died, and because she screamed, the lorry is taken back. And now my son will not be seen, only lorry will be seen in that place. According to which the plaintiff would be allowed to recover the psychiatric illness, provided that this was caused by the reasonable fear of being physically injured by the defendant negligence. Because here the mother and son is a love and affection is there, or not?
Yes, sir.
And immediately the boy cried, and she was present, not in the vicinity, but in the first floor. But still, she heard the sound and screamed, and she got fainted. The boy is dead. So impact theory says, which followed about the 20 years until the decision. Impact theory, it is followed about the 20 years, but later on say, merely listening without the son's death, if you are giving for the nervous shock, so it is not the good way. So Hambrook versus Stoke case law come, and where they are not given for the impact theory. Let us see this Hambrook and versus Stokes case law. In order to extend the law, the bankers LJ was careful to point out that the ratio of the decision was to be confined to a situation where the plaintiff suffered psychiatric illness. Let us see what exactly the Hambrook case law says. Because if you know the facts of the case law, then we can make it Hambrook. Where is the Hambrook case law? Yes. Anyone can read?
Sir, for me, the screen is not.
Yes?
I'm unable to see the case law which you are saying now, sir.
Even now also?
Hi, sir. Now I can see, sir. Hambrook versus Stokes. The
Read.
defendant left a truck on a hill with its engine on. The truck began to come down the hill, crashing into things and swinging side to side. Mrs. Hambrook just had taken her children part way to school and let them walk the rest of the way. The truck crashed near to her, but she wasn't so concerned about her own safety but worried about what might happen to her children. Her fears were justified as her daughter was struck by the truck. Mrs. Hambrook allegedly suffered psychiatric shock, suffered a miscarriage and died as a result. The claim was brought by her husband. The question for the court was whether or not the truck owner owed to Mrs. Hambrook a duty of care.
So here, what happened? The defendant left a truck on a hill with its engine on. The defendant, truck means lorry, is a driver. He left it on the hillside, but engine on. But of course, he might have used the handbrake, it seems. The truck began to come down the hill. I don't know how it is come down because handbrake failed or the steep is more, and it is coming down the hill and crashing into the things and swinging side to side. So it is moving from side to side, swinging and crashing. Mrs. Hambrook had just taken her children apart away to school at the time from that road and let them walk the rest of the way. So she is going on the pedestrian way walking. The truck crashed near to her. The truck came and crashed near to the her of the pedestrian and stopped over there. But she was not so concerned about her own safety, but worried about what might happen to her children. Because the children, she left over there, the children are friend, and she will be back, and she left the corner. She thought the children are died. So her fears were justified as her daughter was struck by the truck. Because the truck came and dashed because she was the corner and she heard the sound. The claim was brought by her husband. The question of her was that whether or not the truck owner owed Mrs. Hambrook a duty of care or not. So now it is a question where, of course, because of this, Mrs. Hambrook actually happened, no, she got the much psychiatric shock and suffered a miscarriage because at the time she was having the pregnancy, she suffered the miscarriage and died as a result. Because of the miscarriage, she died as a result. So now the question comes over here. Whether truck really injured the child? Answer is no. So they said the truck owner could owe her a duty of care. The question has come out. The claimant could establish a cause of action if he would prove that the death of his wife resulted from the shock occasioned by the running of the lorry. Because she died because of the truck coming from the hillside and make a dash against the pathway. Because of that only she has miscarried over there. Because of miscarriage she died over there because of this mishap which has happened, the lorry. That the shock resulted from that, what Mrs. Hamburg either saw or realized by her own unaided senses. Actually, she did not even saw it. She heard only the scream and the smash, and not from the smoothing from one to one told her. But directly she did not see, sir, your son was, the children were died because she was about to cross and she only heard it or somebody told her, and that the shock was due to the reasonable fear of the immediate personal injury either to herself or to her children. So here, she actually did not see the situation. She heard the scream, or she, even though she did not hear the scream, but somebody has told her, because of the thing, she felt it. It is not merely a grief. It is not merely it is a unhappiness. It is more than that is happened because of the such a thing would be there where a big bang has come over there where the children are passing in the road, and of course whether children died here, no, their children are not died over here, but they screamed it, but only that she did not even the scream also, only the passerby saw informed her, so immediately she rushed to it corner and found that the children are not, she did not find it because by hearsay only she got the shock and she miscarried. Because of this miscarriage she died. Why this happened? What is the cause of action first? The lorry coming back.
Very rashly.
Hill అంటే ఏంటిదండి? కొండ. హిల్
down the hill.
చెప్పామా లేదా అక్కడ హిల్ అని?
గుట్ట
ఇక్కడ చెప్పాను చూడండి, కమ్ డౌన్ ద హిల్, crashing into the thing and swinging side by side. Mrs. Hamburg had just taken her children part away to school and let them walk the rest of the way. She has taken the part, only part she has taken. Then say, okay, you children go, the school is in front only. The truck crashed at the time near to her. So that is the thing happened over here. And here say, yes, she is entitled to get the
damages.
Because the truck owner could have owe her a duty of care. So the claimant should establish a cause of action if he could prove that the death of his wife resulted from the shock occasioned by the running of the lorry only. How actually she died? How she actually died?
Because of nervous shock and miscarriage, sir.
Because of the nervous shock got it, throw it, its impact on the miscarriage, the miscarriage impact on the death, leads to death. So that was the thing. So they said, yes, it is still she can be entitled it in that case law. So that is happened over there. Now let us see the another more overall thing. So relationship of here, what is the relationship between the child and mother? Love and relation. Is it or not?
Yes, sir.
The psychiatric illness caused the witnessing a physical injury to a person with whom the plaintiff had no relationship of love and affection. But in the above case law, there is a love and affection relationship is there or not?
Yes, sir, it is there.
It is there because their own children. So nearly the 20 years later, in Boril versus saying what happened? Whether she is going to get any compensation under nervous shock?
No, sir.
No. Why? The question of the psychiatric illness will already come before the House of Lords for the first time. It will be a recall that the concerned a pregnant woman who, while descending from the tram, heard a road accident occur some distance away. Whether the person who died over there is a son or daughter or relative or a husband.
He is a passerby, motorcyclist.
Passerby, a stranger. She later attended the scene of accident saw blood on the road and subsequently suffered a miscarriage and produced a baby shock, produced by shock. And the House of Lords held, in effect, that the woman was not a forcible claimant. In other words, she could not base her action on the wrong done to someone else because she is an unknown person. When she's a chicken heart, why she has gone over there and saw the blood stain? Because the people, those who saw the blood, sometimes they will get the chakrastha, blood. Are you following me?
Yes, sir.
So the landmark case in 1982, the case is McLaughlin versus O'Brien King. This is a very famous case law. And this case law, if you know it thoroughly, yes, even the person is not present over there also could get the compensation. Because there is a law and a relationship is there. And McLaughlin versus O'Brien case law came in this plaintiff was not present in the close proximity. Mother ledu, mother intikad unnadi. Only father and the children are going in a car. Close proximity of the accident. Then the 4 children and father is going, they sustained a nervous shock when she was told about the accident because where the father and 3 children, 1 children died in the spot and 2nd children on the way and 3rd children in the hospital. In the holding of the defendant liable, House of Lords extended the law to recover the situation where the plaintiff had not seen and heard the accident itself, but he had come upon its immediate aftermath. When he heard that met with an accident and he said one person died on the spot, one on the way, another is struggling for the life in the hospital. Merely she heard it, she rushed to the hospital and saw it, and she became in nervous shock. So Lord Wilberforce, and he said, identified there are 3 factors that would need to be identified in every case. Number 1, the class of persons whose claim will be recognized and the proximity of such a person to the accident. Who are the person? What is the relationship between the person and the person who suffered the nervous shock? And where is the immediately or next day or on the spot proximity of such a person to the accident, whether it is there or not. And the last one is here. This is the last one. This is the last one actually. Yeah. Okay. So the means of the psychiatric illness was caused over there. So whether there is a love and affection is there or not, number 1. Whether the more than the shock is not. Number 2, whether there is proximity is there is or not, aftermath. That is called proximity, nearness. And the last one is psychiatric illness was caused because of such a thing. So the 3 control mechanisms suggested by the Lord Wilberforce were subsequently formulated and applied for the unanimous House of Lords case. So what is the first one? The first one says whether the person's claims to be recognized under the nervous shock or not. Number 2, whether there is a proximity, aftermath is there immediately. Number 3, whether relationship is there or not. And psychiatric illness is caused because of the same thing is happened. So these are the tests would be passed over there, then we can say it is a nervous shock. In another case that followed the decision, the House of Lords was somewhat confusing, although it was brought about the distinction between the primary victim and the secondary victim. Who is the primary victim here? Here in this McLaughlin case law, who is the primary victim?
The children, sir?
Children are
Mother,
primary victim.
children.
They actually involved
Yes,
in the accident. The secondary
Yes.
victim, mother, who heard only the father and the people are got injured and the people are died and people are struggling for the life. So the secondary victim. So now here we can say primary victim. An injured person who was involved in the immediate and immediately as a participant is known as a primary victim. Means who got indulged in the event or accident is called primary victim. This category of the plaintiff's description had a wider scope with a later modified Page versus Smith case law is only one case law where the primary victim is going to get the compensation. In all other case law, the primary victim is not going to get the compensation. Because we'll read the case law in detail because I already made it, which narrowed the scope of describing the primary victim as well, who are directly involved in the accident and well within the range of the for severity injury. So secondary victim means who? A person who saw only the secondary victim, or heard only the secondary victim, or came to the spot, later part is the secondary victim. And he suffered only the psychological or psychiatric illness is called the secondary victim. So the provision secondary victim is governed by the decision Alcock versus Chief Constable of South Yorkshire. and who suffers a psychiatric damage even though not directly related to the accident, even when the secondary victim can claim compensation, they will fall under the control mechanism. What is the Alcock case law? I will give the example. There is a football ground is there, Hallsbury football ground. Like I think FI FIFA, something, LF or WF, something, a big, what I say, game is going on over there. Heavy rush is there in the football. But there is some disturbance happened over there in the crowd. Or some unruly mob raged or something happened over there. Then each one is fighting with each other. Each one is fighting with each other. You know, sometimes what happen, there are two groups are there. Suppose one group made the one ball goal, the other group will be agitated. Or they will make the mockery over there. So in the mockery, I believe there is a struggle between the two groups should be there. The police came and they want to curb this unruly mob into the mob. So they made the lathi charge. So when they made the lathi charge, there is a narrow gate is there. When the people are passing from the narrow gate coming out because of the police involved over there, because to make the unruly mob to the ruly mob, and you know, people are fell down in the way. When the people are fell down in the way, do you think that they will keep quiet? They will climb over them. వాళ్ళు తొక్కిపోతారు. ఈ తొక్కిపోయి అందులో చాలా మంది చచ్చిపోయారు. దాన్ని ఏమంటారంటే ఇంగ్లీష్ తెలుసా అండి? The people died, many people died in the stampede అంటారు. దాన్ని ఏమంటారు? Many people are died in the stampede. అంటే తొక్కిసాటలో ఎంతో మంది చచ్చిపోయారు. There is a pool of the blood is there. STAMPEDE, stampede అంటారు దాన్ని. So there is a pool of blood is there and direct telecast is going on over there. Direct telecast అవుతుంది అది. ఏది pool of blood, people are wriggling, struggling, and people are running, and the police is beating and everything. Live telecast is going on. So the people, those who saw the live telecast, and they got the nervous shock. Now whether they are going to get the compensation?
Yes.
They can get, sir, I think so.
Answer, they are not going to get any compensation. The reason is, ఆ 3 టెస్టులు పెట్టినాం ఏది అది రియల్లీ it is a duty is there. Yes, there are duty there, police, to make the unruly mob to the mob. Whether there is a love and affection is there. వాళ్ళ కొడుకు చచ్చిపోయిందా అక్కడ, వాళ్ళ చెల్లె చచ్చిపోయిందా, వాళ్ళ ఫాదర్ చచ్చిపోయిందా? Fancy doesn't come under the love and affection. ఎవరో somebody died over there. And aftermath, immediate గా అక్కడ ఉన్నాడా, అక్కడ చూసినోడు, అక్కడ టీవీలో చూసిండు. ఎక్కడ చూసిండు? టీవీలో చూసిండు. స్పాట్ లో చూసిండు. వాళ్ళ అక్క చచ్చిపోయింది, వాళ్ళ చెల్లె చచ్చిపోయింది, వాళ్ళ నాయన చచ్చిపోయిండు, వాళ్ళ కొడుకు చచ్చిపోయిండు. ఓకే, there is some meaning. So he saw in the telephone and in the TV. That is means there is no aftermath. అంటే ఇమీడియట్ గా చూడలే, అంటే స్పాట్ లో లేదు, అంటే ప్రాక్సిమిటీ is not there. Are you following me? Proximity, nearness to the incident. So the conditions are not fulfilled over there. If he saw in the TV the live telecast and he suffered the nervous shock, he is not going to get it because there is no love and affection, number one. Yeah, it is the Indian tradition that in the beginning or the ending of any program that we will make the play of the national anthem. Now the national anthem will be. Jana Gana Mana Adhinayaka Jaya He Bharata Bhagya Vidhata Punjab
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।
Jai Hind.